just before you start, Mr. Gilroy, there was, as you probably had explained to you, some problem with the CV, the link. Anyway, I'm not sure whether it's been resolved. If it hasn't, I'm sorry, that affects really Mr. Southey and Mr. Devereux, but obviously their solicitor will be following slightly less satisfactorily on live stream and can presumably communicate with you with the disadvantage of some delay. If that creates a real problem, we can give you a few minutes, but hopefully it won't.
So far, it certainly hasn't.
Yeah. Good. Okay. Yes, Mr. Gilroy.
My lords, I hope you now have the chronology and the glossary.
Not consciously.
No, it's just that.
Oh, this is it. I see. Sorry. Yes. The answer is yes, we do that. But thank you very much for that. Is it an agreed chronology?
No. It's the respondent's chronology.
Well, we will check all references just in case. Right, thank you, but I'm sure a useful piece of work, and thank you for whoever did it.
I will be referring to it at some points. My lords, just before the break and before I started, Mr. Southey, on behalf of Kent County Council, said that there hadn't been a previous example of a case like this. I'm not quite sure what he meant. It may be of a lawful application for entry clearance, because in the third witness statement of Janavi Gosai, who is my instructing solicitor, that's respondent's bundle, she gives an example of a family also accidentally separated. Paragraph 61 to 62, her witness statement it's at page 63.
Small bundle with columns.
Small respondents bundle. The witness statement starts at 63.
Hang on, I have what I thought was a small respondent. Oh,
63. It's got 2 terms and about 132 pages.
I have it now, yes, thank you. 63.
And what you will see at paragraph 61 to 62 is what the usual response to a situation.
You say, wait a minute, you said page 63.
Is where the witness statement begins at page 63. The page
Which
that
page
asks
are the pages
74 to 75. Paragraphs 61 to 62. I do apologise.
No, don't worry at all. Just give me a second. Right, yes.
And what you will see there is the usual response in a situation like this, which is that nothing is done, and what is awaited is the arrival of the parents unlawfully, and that is exactly what happened in this case.
Just give me a second. The 62, 61, yes, sorry.
61 and 62.
Yeah.
Was there anything, any reason to take that course other than just an assumption on our vote?
Yes, well, you'll see from, and in the chronology, the references are there. In this case, you'll see the conversations that are disclosed between Kent County Council and the Home Office. You can see the thinking of it. It's at pages 313 of the supplementary bundle 1. And these materials, importantly, were in front of the upper tribunal. So this is what the judge was aware of when she made her decision. There was just an assumption that the parents were going to come. The important point is that nothing was done.
Should the parents arrive, they should be provided with family accommodation.
Yes, and there were, what the Home Office, what you'll see from those exchanges is that what they were particularly worried about is getting the right date of birth for the children, because the children were young and they weren't sure they were giving reliable dates of birth. And so they were worried that if the parents arrived, they would not be linked with the children when they arrived, and therefore the reunification would not happen as speedily.
But I haven't quite understood what's... That's not in a way condoning, that's just facing a reality that parents who've been separated might, it turns out they didn't, but might attempt to come again by small boat and might succeed.
I accept that, but what it also shows is the absence of any proactive steps taken to reunify these children with their parents. So the first thing that was done was the parents applying for entry clearance on the 21st of August.
Yes.
Now, the responsibility for instituting a process of returning or removing the children to France to join their parents lay with the authorities here. It was they who had the mechanisms and the resources at their disposal, the negotiations with the French authorities in order to institute that lawful process of removal to France. And that was not done and has not, as far as I'm aware, ever been done. This case has stimulated, because the Secretary of State is unhappy with the upper tribunal's order, this flurry of negotiations that you see in the witness evidence produced after the upper tribunal's order, to try and institute some sort of process for a lawful reunification in France. But in my respectful submission, what was not done and what should have been done is for that process to start immediately.
So what your point was, that wasn't the way the Home Office was dealing with it
No.
at that point. It was just assuming they'd come on the next
Just
boat.
assuming they would come on the next boat. And the assumption was so entrenched, my lord, that the foster carers were told by Kent County Council to communicate this expectation to the children. And I'm going to show you the evidence. The children ran down the stairs every morning, expecting their parents to arrive on the boat, having been told by social services that that is how they were going to arrive. And this is in circumstances where the children had witnessed a drowning on the way over in the boat. The Secretary of State had sent a chief immigration officer. This is the sort of official response that the Secretary of State did take. A chief immigration officer shortly after their arrival to interview them, children aged 5 and 9, about what they had seen in order to pass it to the police. That was what was done. So they knew that these children were traumatized by what they had seen. And what the foster carers report in their evidence is that the children were terrified. They were simultaneously desperate to see their parents, but terrified because they believed that their parents might die on the journey. Now that is
I ought to be clear about this.
Yes.
Forgive me. At what point did contact resume in direct contact in some form or anything?
It's
Is it
on
in the
the
chronology? Just tell me to.
25th of July. It's all in the chronology. 25th of July, 2024. The first video call between the parents.
Thank
They
you.
thought they would. In fact, they thought they were dead. The father was dead. And you'll see
Who thought the father was
the
dead?
children. Or the older child. I think the younger child.
So it was 6 days later.
6 days later. But that did not prevent the message being sent continuously to them that the expectation was that they would arrive by boat, until, of course, the parents made their lawful application. And at that point, the expectation was communicated to them that the parents would arrive lawfully. No one was ever telling the children at any point that they were going to be sent or returned or removed to France. That was not the expectation of anybody involved in their care until shortly before the upper tribunal hearing, when the Secretary of State finally decided that that was the course that she
What's
wanted to take.
the significance of what the children were told about whether they would be reunited with their parents in England or in France? The important thing to them, presumably, would be to be reunited with their parents.
Well, the significance of it is their expectations of what was going to happen and what they have been told over months as part of the way in which the foster carers have dealt with the trauma of the separation. And so what you will see from the evidence in front of the upper tribunal, the psychiatric evidence, but also from the foster carers, is that such stability as they have, such expectations as they have, were all based on the parents coming to join them.
Adds to the psychological harm.
Sorry?
Adds to the psychological.
It adds to the psychological harm.
I see that, but surely what adds to the psychological harm is remaining separated from their parents.
I absolutely accept
From
that.
their point of view, I don't think this matters for the. Now, from their point of view, differently from the parents' point of view, it wouldn't matter whether they reunited in France or in the UK.
Well, it does now, because what the evidence is that they are stable in the United Kingdom. They have, aside from the trauma of the separation, they are going to school.
Yes, I see that.
They have built links, and
The elder one has certainly learned quite a lot of English.
they've learned English. So time has passed, and their behaviour, as you will see from the evidence, has significantly deteriorated. However, the one stable and constant thing in their life is the school, the experience they have at school, and the links that they have built up here over this period of delay. I tell you about what they were told about the parents coming here, just to show you that this is what the expectation has always been of those authorities involved in their care.
And transmitted in some
And-
form or another to the children.
And transmitted to the children.
Yeah.
And so,
Well, I don't think there's any doubt about that. I mean, the idea of reunification in France came up very late. And
It did.
And that James acknowledged that.
well, it came up very late, but my lord, one of the things that is being said, has been said repeatedly today, it also appears in my learned friend's skeleton argument, is that somehow the parents should now, after the order of this this jurisdiction's courts, that they should be admitted, which has still not been overturned. It's not even arguably unlawful at the moment. That they should, contrary to the evidence of the psychiatrist, contrary to the position taken by all the authorities of this jurisdiction, that they can't assess the best interests of the child. They need information about whether it would be safe for their health to remove them to France. But my learned friend says the parents are to blame, because what they should have done after this long, extensive delay, in which they were the only ones who were taking the action necessary to reunify with their children, they should now perform a complete volte-face, take a decision contradicting all the evidence that was before the upper tribunal, and decide that the children should be returned to France, not without any assessment of the harm that would do them. Now, in my respectful submission, that is simply unreasonable. No responsible parent would take that position. The delay in this case has caused these children considerable harm, and it has also meant that they have, as I said already, the minimal stability that they have achieved is in the United Kingdom. And so the obvious and correct solution to this problem, which has arisen not as a result of the parents' failures, but the Secretary of State's, is for, on this occasion, the parents to come to the United Kingdom, as the upper tribunal has ordered. And she was, I will come on to whether she was correct, as I've said, she was on the evidence before her. But what the Secretary of State and Kent County Council decide to do in future cases is something quite different. Now, one would hope, although it is not clear in fact, because there's no indication of this in any of the evidence before you, that in future cases they would immediately spring into action to achieve the goal that they now say should be achieved, as opposed to wait for the parents to arrive unlawfully. And that will be a quite different situation that comes before any court asked to consider.
But can I take you back to what you,
Yes.
when you say not the responsibility of the parents, what precisely do you mean? Is not
The delay.
responsibility?
The delay. I accept, of course, that the parents boarded the boat and that decision was theirs. But everything that happened afterwards, their separation from their children, they were attacked, and that's why the children thought they had drowned. The delay that then occurred here is all down to the authorities of this jurisdiction. Cannot be laid at their door. Now, it is true, my learned friend, the high point of my learned friend's case on this is that the parents, when asked, with an open question, I should say, where would you prefer to be, do you want to be reunited with your children in the UK and France? And they said the United Kingdom. But what was said in those, as my learned friend fairly admitted in the correspondence that followed, is that there was no intention then to pursue a forcible removal of the children to France. So the parents, having been asked where they wanted to reunite, they gave their answer. They had their reasons,
Well, there's nothing in the least bit surprised. They were trying to get to England in the first place. It's not
they
clearly
were,
where they
and they
wanted
do
to go.
have subjective fears. My learned friend is very critical of their fears, but they do have subjective fears of harm in France. Now, it may be that on proper examination, those fears will will turn out to be unfounded. But no one is suggesting that those fears are made up. These are asylum seekers who may well be refugees, and they are fleeing persecution. They have been told, and they understand, that persons in their category of persecuted group are at risk in France because others have been attacked. And so that is why they have made the decision they have made. Now, no one has ever presented to them before these appeal proceedings that their children should in fact go back to France. And that is the suggestion has been made at a point at which so much damage has been done by the delay that they cannot reasonably be expected to agree to that.
One way we may want to think about this is what the position would have been if there hadn't been delay, because that would enable us to work out really what the operative considerations in this case really are. Suppose the position that everything that has now started to be done, starting in October but gathering pace in the last couple of months, had started in late July. We obviously don't know what the outcome would have been, but if proceedings had been started when they were, and the evidence before the judge then was what it is now, because that's roughly how it would have worked, would the judge have been entitled to say they must have entry clearance now?
Well, my lord, I don't see how I can reasonably answer that question, because the situation would be entirely different. For a start, the evidence about the harm to the children may well have been different. The evidence about the parents' position may well have been different. The issue, the delay here is the critical factor, because what it does is it fixes the point at which you are being asked to consider this application for permission to appeal an appeal at the stage of the hearing before the upper tribunal judge. And aside from legal questions, I quite accept that any legal errors that may have been involved in the decision need to be examined, and I'm going to address those. But as far as factual possibilities, in my respectful submission, I can't properly answer that question. What I can say is that if the evidence showed the type of harm from removal to France and from continuing delay, which was before the upper tribunal judge in October, I would be arguing that the same order should be made. Because the critical issue, as I started out with before lunch, is it lawful to inflict this harm of waiting until this process is resolved?
We've established that the harm you're talking about is the harm caused by delay.
It's the harm caused by the delay.
Discussed earlier, wasn't it?
Yes, and well, the delay and therefore the prolonged separation.
So really, perhaps it follows from that half answer to the Lord's question. But without the delay, the case would be completely different. Your case would not have such strength as it has.
Yes.
Yeah. I mean, the problem is the ambiguity of the word delay. Perhaps a less pejorative way of putting it is passage of time. Even if the passage of time was nobody's fault, your case would be to some extent based on that.
I would still, a court considering this question is probably the better way of looking at it, would still have to take into account the harm to the children, because that harm is relevant to any decision that you would have to take. But in this case, what you're being asked to do by the Secretary of State is to overlook the culpable delay.
Not just the passage of time. In your case is it's passage of time plus culpability.
Yes.
Yeah.
Which has caused harm to these children. The Secretary of State could and should have acted as soon as these children arrived to put in train the processes for achieving a lawful reunification wherever it was in the best interest of the child. They would have had to consider where the best interests of the child, which place the best interests of the child militated in favour of course, balancing it against other considerations. I accept that, unless there was Article 3 harm. But in an if the harm had not yet reached the Article 3 threshold, then they would be entitled to balance it against the public interest. But that is not what has occurred here. And that is why this is a quite unusual case. And none of this has been taken into account in the assessments of precedent, risk, for future conduct, smuggling gangs. None of that has been considered. And you can see that from the witness statement of Ms. Emelek. Not only does she not consider the Secretary of State's delay, in fact she thinks it's perfectly lawful to continue to delay, but she also doesn't consider the impact of the accidental separation.
Well, I think the word delay really is ambiguous there. If you're suggesting that the government is not now doing everything as quickly as it can, based on, it's not doing everything as quickly as it can, you'd have to demonstrate that was the case. But I thought your real point was they've started too late.
Yes, that is my real point.
Yeah.
I apologise if I wasn't clear on
Is
that.
it past delay, passage of time and culpability, or past delay plus future delay
Yes.
without culpability?
Yes. It's past delay, and we are now in a position where even with all the efforts that the Secretary of State has made, it is not possible for her to predict when and how these children can be sent,
Yes.
removed to France. And we are looking at, with the family law proceedings, which is the basis of the evidence before you. My learned friend has, it appears, backed away somewhat from relying on those family law proceedings. But they are not due to be concluded on a best case scenario until the end of February. And that's if the hearing in January goes the way that Kent County Council wants it to go. And I've already outlined in the note this morning the arguments as to why it very well might not. So the future delay in this case is considerable, and it has to be added to the past delay, which is culpable. But the overarching consideration underlying all of this delay, culpable or otherwise, is that because of the length of time, the children are now suffering serious damage, which is likely to be irrevocable, and it gets worse with every day. And so the question is, in circumstances where there has unquestionably been fault on the part of the UK authorities, there is no certainty as to when this family can be reunited in France, or even if they can be reunited in France, because the conclusion may be on proper examination of the up-to-date evidence. Remember, the up-to-date evidence will be in February, by which point further damage will have been done to these children. So even if they will be reunited, that is the question that this court has got to consider. Against that backdrop, is it lawful for these children to be deprived of the benefit of this order? And my lord, I will come on obviously to the my principal argument, which is on the basis of what she had in front of her. The upper tribunal judge was unquestionably correct to reach the conclusion she did. She foresaw precisely the situation that has now arisen, the uncertainty about process. My learned friend couldn't answer this court's questions about the length of time that it would take if the parents consented, which he claimed that they should, and I've already given the very good reasons why they should not. They should not be expected to make a decision that no one else is prepared to make because they're not sure it's in the children's best
Well,
interest.
you can't be precise about how long these things are going to take because of the nature of the way the Hague Convention works.
Well, I
Again,
understand
it all
that.
depends on the individual.
Yes.
It all depends on the individual states concerned and the operation of their central authorities.
Yes, it does, my lord. And the point is that the point that I'm making about the delay that happened before the upper tribunal judge hearing is that she was entitled to conclude that given the evidence she had of ongoing harm, given the fact that as things stood before her, these discussions, some of the discussions that you were taken to between counsel for the Secretary of State and the French authorities, Kent County Council and the Home Office, had not occurred, not even begun to occur before her.
Right, we've done this inevitably happens. You made some introductory remarks and they've led us further down into your submissions. We'd probably like to take a step back and get back onto a structure, but
yes,
thank you.
thank you. So, my lord, this is pleaded as an Article 3 case as well as an Article 8 case, and I just want to give you the references in the detailed grounds. Paragraphs 40 to 56, call bundle 289 to 293. The upper tribunal found both of those claims to be arguable. That's in the core bundle 218. And I would actually like.
Sorry, that's simply the grant of permission.
That's the grant of permission. But what's
I don't think that's reasoned, is it?
it's not reasoned.
No, which it doesn't have to be, but
It doesn't have to be reasoned. But the point is, she found it to be arguable, and the way she put it, the respondent's failure to act is in breach of the Article 3 rights of the minor applicants, who, according to the expert evidence, adduced have suffered a serious deterioration in their mental state owing to the separation from their parents. So that is what she concluded on Article 3. Why is this an Article 3 case? My lord, I've already outlined some of the reasons why that is, and I would like to briefly show you some of the evidence. But as I've told you, they suffered intense daily distress from the separation. They were told the parents were arriving soon by boat. They ran down every morning to see if they had. The other factor that the evidence describes is their anguish in seeing their parents only remotely. It has become so traumatic for them that sometimes they don't want to see their parents at all. They have doubts about whether their parents love them. They have emotional outbursts that they can't control. There are physical consequences. The younger one is soiling and wetting himself, which he's never done before, and having tantrums and meltdowns. And this evidence is all set out in the skeleton argument with references, paragraphs 12 to 15. My lord, the psychiatric report, paragraph 15 of the skeleton argument sets out these passages. What she describes is the potential for long-term damage, including emotional, cognitive, identity formation, metabolic and cardiac. So this is mental, emotional and physical.
it's not based on any examination.
It's based on her experience and on looking at the documents, yes.
Yeah.
But no one else has done an examination.
No, it's not a criticism. I just want to be clear about this, because when you say about things like cardiac, you might think, oh, well, there's been some examination of their hearts.
No.
This is more general, based on her experience, that if you have this degree of trauma at this age, in 10, 20, whatever it is, years' time, you can have heart problems.
Yes.
Yeah, okay.
Of course, I recognise your point is this is on a very high level. This type of harm is sadly not unknown in children who are separated from their parents by being taken into care. Your point is at extreme level.
Yes. No, my lord, it's not my argument that harm like this does not occur in other situations, but this harm is preventable. It can be brought to an end by reunification immediately, and should have been. Now, paragraphs 26 to 27 of the skeleton argument describe the escalating harm since the interim relief hearing. So the harm is continuing to build. since then. My lord, the responsibility of the UK authorities, and I do want to show you one of the witness statements of the foster carers. So it's in the supplementary bundle, page 263.
We've got 4 supplementary bundles, which
It's the main supplementary bundle. So the supplementary bundle, the main one, is the evidence that was,
it's just, in our case, it's called what, isn't it? Yeah, okay, it's called 1.
it's called one, and what's important about it is this is the material that was in front of the upper tribunal judge. So it's easy for you to see
Yeah,
what she had when she was making her decision.
yes,
Everything else post
it's
haste.
subsequent, yep.
So 263, and you'll see first of all at paragraph 10, we were not told how long it would take for their parents to arrive in the UK. This is when they were first given the children. All we knew is that the children would be under our care during this difficult time, and their well-being was our priority. Then at paragraph 13, the reference to the
Sorry, where were you reading from?
at paragraph 10, page 262.
Yep, thank you.
At end of paragraph 13, one of the children, the elder one, feared his father was dead. So that was a description of when he first saw him at paragraphs 10 and 14. And then you'll see at the end of that paragraph, the foster carers, this is in the middle, a few lines down from the end. I did our best to reassure them that their parents would be here soon, but we did not know how long the entire process of reunification would take, which has made it difficult. It has also been difficult because at that time social services understood the parents should be arriving by boat, and this really scared MIK. So it was hard to reassure them reassure him they would come, while also not scaring them about how they would manage to join them safely. And you'll see then at paragraph 15 what I've already described.
Yeah.
Wake up every morning and run downstairs. And then you'll see at paragraph 18 as well, description of them not engaging with the calls with their parents. I think the children might be punishing their parents for not being with them, or they just find it too painful being on calls then knowing their parents are far away. Sometimes when there were trees in the background where the parents are, this was scary for the children as it reminds them of when they were all in Calais. That's something to bear in mind. The children find France a frightening place themselves. That is their position. Confirmation at paragraph 21 of the close bond between the parents. Paragraph 22, the way in which MIK and MAK were separated from their parents is heartbreaking. I'm really worried about the long-term impact this will have on them. I'm worried that this will be something they will struggle to forget and recover from. And at paragraph 44, this is a statement dated the 26th of September. It has been over 2 months of waiting, and these young children are under a lot of stress and are really struggling. I believe it is really urgent that their parents join them, and fear it will be harder for them to recover from this traumatic separation the longer it goes on. So that's 3 months ago.
But of course, the suffering the children suffered in the first 2 months, realistically, however quickly people had acted, they would have suffered in any event.
Well, they might have done, or it might, if an assessment had been made at that time, it might have been concluded it was quicker for the parents to come here. A lawful decision would have to have been made at that time based on the evidence before the decision maker. But I obviously accept that any period of separation at that time is likely to cause some damage. But the point is that we are at a point where there has been extensive separation, and that is the situation that was before the upper tribunal judge, and it's the situation before you.
Well, there is evidence before us. There's evidence before Mr. Justice Garida in Anne Nerve's statement. I'm not sure whether it's before us in any other way. The children were, I don't say say settled down, that's the wrong
Yeah.
phrase, but you're making very good progress at school, you're sleeping well, eating well, seeing an aunt who lives in contact with her, in which they were observed to visibly relax and be at peace. Is it the case that, how does that impact upon the harm that they are now suffering? It sounds so callous to put it like that, forgive me.
Yes.
I'm just focusing on the issue about ongoing harm.
What the foster carers describe is that they seem to be settled at school, and as soon as they come home, that is when they exhibit the difficult behaviours. So the point is that the school is that's the point I made earlier on, where it fits is the school is the anchor of stability. That is a place where they can forget that they are separated, it appears, from their parents. But when they are in the home with their foster parents, that is the place where they should be with their parents. And that appears to be, from the evidence that was before the upper tribunal, the foster carers' evidence, the trigger for some of this deteriorating behaviour. So in my submission, that evidence indicates first that there is a real premium on these children staying in the United Kingdom, and there would be damage to them from being uprooted at this point. That is the view of the psychiatrist who examined them. And secondly, that there is, it doesn't in any sense undermine the evidence about the damage to them from the separation.
It's not a strictly cultural match, is it? But foster carers are not from the same background. I've read that somewhere.
No.
But they are experienced foster carers.
They're very experienced
in caring for asylum, the children claiming asylum.
Yes.
Or are subject to asylum, for instance.
Yes, they're very experienced, and what you'll see is that when you read their statements, and I do urge you to do that, is that they say this is they've never had to deal with a case like this, notwithstanding their experience. So that's the expectation is that the parents would arrive by boat as part of the cruelty to them, the failure to take any expeditious steps to bring the suffering to an end, and then the 3 months delay. My lords, in my submission, the attempts that the Secretary of State has now made to block the arrival of the parents in the United Kingdom is part of the cruelty to these children, because it's important to recall that pursuant to a lawful order of the upper tribunal, which had not been complied with, deliberately not complied with by the Secretary of State, and that finding has not been challenged in this appeal. So there was a deliberate non-compliance with the upper tribunal's first order of the 31st of October. The parents were at the airport about to join their children that day on the 19th of November when the stay was imposed. And for the findings on breach of the order, it's call bundle, tab 13, pages 225 is the start, and it's at 230.
So what is this a reference to? Is this a reference, reference to
the upper tribunal
Judge Hurst's judgment?
Yes, that's right. It's paragraphs 25 to 31. And she concludes that there has been a deliberate non-compliance with the order.
And just so we're clear about that order is in fact appealed, although it is true that I have not seen in the certain argument any addressing of that particular point. But
No. The order was appealed on the basis that, on a very narrow basis, that she should not have refused the stay, but should have, and should not have ordered enforcement, should have waited for the Court of Appeal to consider the permission to appeal application. But what was not challenged was the
I think
findings.
if you're placing weight on this, which I understand why you are, but I would just like to see what you said.
Yes.
I mean, I've looked at this, but I haven't focused on this particular aspect of it.
Well, this is
Well,
important.
I was certainly very well aware of the disappointment because the parents, perfectly understandably, were at the point were at the airport. Well, I wasn't aware of the finding of deliberate disregard of the
2:30.
earlier order.
2:30, so it starts at 2:25. And it's paragraphs 25 onwards. It's apparent from the evidence presented to the
Hang on
court
one
today.
second.
Page 230.
Yes, I'm just, sorry.
That the respondent has not taken any meaningful or effective steps to comply with the order in the 2 weeks since it was made, despite being aware of the urgency of the situation and the evidence of ongoing detriment to the children's well-being.
But sorry, can I just be clear about this? Why were the parents, this may well be the case, but there was no point of them booking a flight order until they had been assured that they would be given entry.
Well, what she ordered after this hearing was that the Secretary of State get ready prepare the documents to allow them to travel, and that they and admit them and comply with the order to admit them to the UK. It was at that point that they booked the flights. But
Yes, I see, but it was built into that order
yes,
that it shouldn't take effect until there had been an opportunity to apply for a stay to the Court of Appeal, which was then done.
well, it was built into that order that the flights should not be booked. So she didn't grant a stay, but she said the flights should not be booked until, you can see the order that she made at page 225.
Yes, well, I've looked at that.
Should not be booked until a time, in other words, 5 p.m. On the 19th of November, to give the Court of Appeal the opportunity to impose the stay,
Yes.
which had already been applied for by that point. So that is what she ordered. But the point about it is the reason why she made the order, or some of the reasons why she made the order that she did. Obviously, the Secretary of State was required to comply with the order of the 31st of October until it was
It's the order of the
appealed.
31st of October. The problem, fine as a first order, is it was unspecific. It used language like as soon as
As
possible.
soon as possible. Ordinarily, they do.
But the first order,
Yes,
yes, no, I'm not criticising anyone, I'm just
yes,
getting it clear in my head. Because 2 weeks later, nothing had yet happened,
yes,
you went back to Upper Tribunal Judge Hurst, or rather less than 2 weeks later, 10 days later, whatever it was, and said, enough is enough, we now want a firm deadline.
yes.
Yeah.
Effectively. And as part of that argument, she considered the evidence as to whether the Secretary of State had taken the necessary expeditious steps to comply with the order and concluded that she had not. And you can see that at paragraph 25 and 26.
Yeah.
As she said at paragraph 27, the steps that were taken, far from representing efforts to comply with the order, indicated active efforts by the respondent not to comply with it. It's not open to the Secretary of State when the court makes an order with which she disagrees, simply to adopt a policy of non-compliance. And she also criticises the evidence that was before her on the basis that it gave a misleading picture, because the Secretary of State put in different witness statements, and you've alluded to this yourselves, my lords, which is that MIK 3 was the witness statement.
Yes, which
put
we
into
haven't
the
got,
upper
yes.
tribunal. Well, it's in here. It is in this.
Oh, is it? Oh, I see, we haven't
We
got
have
it.
got it.
Wait, just tell me where it is.
I'm just trying to find it. Well, it is in the bundles. I can see it actually not. It's not in the core bundle. It's in the supplementary bundle.
Well, I did look for it, but
So it's supplementary bundle
Tab
number
50.
2,
yes, thank you,
page 302.
thank you.
No, it's not. It's supplementary bundle 1 because tab 50. That's the one that was before the upper tribunal
On the second occasion.
on the second occasion. Yes.
I'm so sorry, Miss Joy, what page in bundle 1?
Supplementary bundle 2, I think you said.
302.
In 2?
No, it's up on the wall.
In 1?
In one,
in-
so sorry,
in
I'm
one.
confusing everyone. 302.
So So that is the statement that was put in front of the upper tribunal for the
In fact,
enforcement.
that's the one which upper tribunal Judge Hurst
It's critical of.
analyses at 25 and 26. Is it?
And 29. What she says is apt to give a misleading picture, because what the statements that were put in simultaneously to the Court of Appeal showed was that in fact what had been happening since the order was made was that concerted efforts had been made to send the children to France, not to bring them to the United Kingdom, without an application for permission to appeal being made. So
I mean,
was
that
the-
would be unobjectionable if, if they were appealing
Yes.
against the first order, and as would be necessary, probably seeking a stay, it's not a contempt not to comply with it in the meantime.
But they hadn't, so that was the point. They did not put in their application for permission to appeal until the night before the hearing in front of her. And
Yes,
so
I see.
in the interim period, they had been adopting a policy of non-compliance with the order. That was what the evidence before her
Yes,
showed.
okay, thank you.
Adopting a policy of
Well,
non-compliance.
they had decided not to comply with it. And what she saw, the evidence before her was that a submission had been made to the minister on the assumption that there would only be compliance with the order if an application for a stay of the order had been refused, but no such application had been made. So that was the conclusion that she drew.
There was a policy of non-compliance. Is that what
That's
it
what
is?
she says. I'm just quoting the judge.
So exactly where it is?
Well, she says it's not open to the Secretary of State when the court makes an order with which he disagrees, simply to adopt a policy of non-compliance.
Sorry, please.
Paragraph 28. I do
Of
apologise.
Upper Tribunal
Of two- of-
Justice.
of the judgment in the.
Yes, I just want to make
page 230.
be sure what this criticism is and what it goes to. What it goes to effectively is ratcheting up the disappointment and therefore the harm, because there is immediately after the order of Upper Tribunal Judge Kamara, they had every reason to believe that reunification would happen in the UK soon. That obviously can't stop the Secretary of State bringing a legitimate appeal. Your point, though, is that should have been done straight away and an application for a stay made, so that everyone realised that nothing was that they couldn't rely on Upper Tribunal Judge Kamara's order because it was being appealed and an application for a stay was made. Your criticism is 14 days went by before that happened.
Yes,
Is
my
that-
criticism is twofold. One, the parents were at the airport, and that was part of the cruelty towards them. But secondly, the Secretary of State, effectively that conduct reveals the truth of this challenge before you, which is that there wasn't a legitimate basis for criticising the Upper Tribunal's judgment, or at least not a strong basis, on the evidence that was before her. So what was sought to do before the application for permission to appeal was made was to conduct last-minute negotiations
Beef up
with
the case.
to bolster the case. And the application went in with new evidence.
Yes.
So that's where it is. Otherwise, the application for permission to appeal could have been lodged straight away. But it wasn't, because there wasn't a proper basis for it. Now, so, my lord, these are all parts of the backdrop to why the Secretary of State's conduct in this case amounts to, when combined with the harm to the children, amounts to an Article 3 breach, in my respectful submission. All of this shows that this, what is now being done, should have been done sometime earlier. My lord, I would now like to look at my learned friend says that it can be distinguished, but in my respectful submission, not on this issue of harm, because what you see there also, this is at tab 39 of the authorities file.
Hang on one second,
it's
just making a
volume
note, just making a
2.
note to myself. Give me- sorry, yes, it's second authorities bundle, is that
It's the
right?
second authorities bundle, tab 39, it starts at page 814.
Yeah.
And you'll see that this is a case where there were two applicants, a mother and a daughter. The mother was granted refugee status in Canada. She then, this is from the head note at 814, she asked her brother to collect the second applicant, who was then 5 years old, from the Democratic Republic of Congo, and to look after her until she was able to join the first applicant in Canada. And then when she arrived at the airport, the child was detained and that delayed the reunification of the child with the parent. But what you can see at paragraph 58 is that part of the criticism of the approach that was taken by the court on that occasion, the state on that occasion, is their failure to use the array of means at their disposal to provide care for the second applicant. The court is in no doubt that the second applicant, that's the child's distress in the conditions described above, this is in detention, caused her considerable distress. Now, my lord, the important point about this, what my learned friend says is, oh, well, this was detention. But the reality is, the issue is, what is the harm? The harm is the distress. Nor could the authorities who ordered her detention have failed to be aware of the serious psychological effects it would have on her. Similarly, here, no one could fail to be aware of the serious psychological effects it would have on the children of this extensive delay. In the court's view, the second applicant's
So
detention...
where are you reading from now?
I'm still in paragraph 58 at the end of 8.
Yes, okay, thank you.
Nor could the authorities have failed to be aware of the serious psychological effects it would have on her, going over the page. In the court's view, the second applicant's detention in such conditions demonstrated a lack of humanity to such a degree that it amounted to inhuman treatment.
What are the conditions?
She was detained in an adult detention centre. So amongst
For how
adults
long?
with for 2 months, I believe.
How old is she?
5.
They're very different facts.
It is very different facts, but of course,
So
I
as
said
opposed to
that.
being with foster carers who cared for 30 children in similar circumstances.
I absolutely accept that it's not the conditions that the children are being held in that is causing the damage to them. It's the delay in reunification over an extended period of time.
Yes, but I'm not. I was assuming you were taking us to this to demonstrate that that this is capable of reaching the Article 3 threshold.
Yes.
But that rule depends on the facts. The facts are so different. I don't know it shows us it reaches the Article 3 threshold at all.
What I'm showing you is that in the part of the context in this case was a failure to reunify. It's partly the conditions. It's partly the failure to reunify. This case also deals with the Article 8 obligations on the Belgian state.
All right, but one thing at a time. I thought I haven't quite got the structure of your submissions, but I thought we were on Article 3.
We are, my lord. So
the reason you're taking us to this is, I thought, for the reason I just summarised to you, that it would show us the Strasbourg Court finding a breach of Article 3 in similar circumstances, but they're not similar circumstances, so I'm not
except
sure
they're
it
not the
helps.
same circumstances. But in my respectful submission, what you see from the reasoning is that what the court is focused on is the distress to the children and the serious psychological effects that it would have on
Yes,
them.
but inhumane treatment, it's not simply a question of distress. It's
Yes.
got to have a look at the character of the treatment. Keeping a 5-year-old in an adult detention centre for 2 months away from their family, I can quite see why that was found to be inhumane treatment. The fact that she will have suffered distress and the children will have suffered distress in the present case for a very different reason, namely separation from their parents, doesn't mean that the two cases are comparable.
No, I wasn't seeking to say that the two cases were comparable in that sense, but in my respectful submission, what it shows is, what you look at is culpability of the state for the suffering that the child, that is inflicted on the child, and then the suffering that the child undergoes. And in this case, I've shown you, and there are further references in the skeleton argument, the type of suffering that they are experiencing, which includes serious long-term psychological and physical consequences, the intense daily distress, and all of that caused by avoidable, and I say culpable delay.
I see how you
So
put it.
that is the basis of the argument, and you can then see, so that's paragraphs 50 to 59 describes that. And they then say that they reiterate, which I know you won't need reminding, that Article 3 affords absolute protection irrespective of any reprehensible conduct on the part of the applicant, and a fortiori on the part of the adults, if there had been in this case. And then there is also a finding of a breach of Article 3, not just on the detention, but in relation to the deportation. So you can see that at paragraphs 66 to 71.
But that's even further from the facts of this case. And I don't mind, use your time as you wish, but is this really going to help us?
Well, my lord, the comparison here is children who are very young, who are suffering extreme damage as a result of actions in relation to immigration on the part of the state.
Yes.
And that is the comparison. I don't need to take you through it any more than that, but I just want...
No, I see. Thank you. I see how you put it.
I'm relying on it for that reason. I don't say it's obviously different, as all Article 3 cases often are. But what the court focuses on when examining whether there's been a breach of Article 3 is, yes, the circumstances, but also the impact on the child. And in my respect, the threshold is reached in this case. Notwithstanding, no one is for a moment criticising the care that's been provided by the foster carers, but what their evidence shows is they simply cannot contain these behaviours because of the harmful impact of the separation. There are other authorities that are relied on in the detailed grounds of claim. E and Chief Constable, and I won't ask you to call it out again. These are all. This is a different situation. Paragraphs 7 to 9. It's at tab 13 of the authorities bundle, pages 158 to 159.
Okay, but what's the proposition which you're taking us, which you're not taking us to for, but
The
asking us to
proposition
have in
there, in
mind?
that case, it was the potential for harm to the children. In fact, they concluded it
It's
had
an
been
Article 3 case.
Article 3 case from the way in the treatment that they received when they were going through a contested march area in Northern Ireland, and you can see the court acknowledging again the way in which the children experienced the abuse that was hurled at them, potentially amounting to Article 3. So it illustrates another type of conduct which can cause harm to children. In that case, what was relied on was a positive obligation to prevent that ill treatment by third parties from the abuse that they received while passing the march on the way to school. Tarakel and Switzerland, my lords, is perhaps more on falls with this case. Tab 42, paragraph 99. Page 974. And this was a case about removal to Italy and the risk of removing them to reception conditions which were unsuitable for their age. At paragraph 99, you'll see, first of all, reference to the need to consider the child's vulnerability when addressing this question. The court has established it's important to bear in mind the child's extreme vulnerability is the decisive factor and takes precedence over considerations relating to the status of illegal immigrant.
But my had to look at this case in some detail in an earlier decision.
Yes.
It was it was about the risk that they would be separated from their parents altogether,
Yes.
or if they were, will be put into in very substandard detention centres where there was no facility for parents and children to live a family life.
Yes. Well, my lord, it's paragraphs 118 to 119 and then 122. And you'll see there that even where accompanied, the conditions could be so unsuitable that they would lead to a breach of Article 3.
Yes.
And they emphasise, and this is really the point of principle, that the assessment of whether the minimum level of severity is reached is relative and it depends on all the circumstances of the case, the duration of the treatment, physical and mental effects, and in some instances the sex, age, and state of health of the victim.
Yes.
In my submission, all of those factors apply here, and that recognising at 119 the extreme vulnerability of children and the need for reception conditions to be adapted to their age, so that those conditions do not create for them, this is in the middle of 119, a situation of stress and anxiety with particularly traumatic consequences. Otherwise, the conditions in question would contain the threshold of severity required to come within the scope of the prohibition under Article 3. And again, what has happened here, given the length of time and the effect on the children, crosses that threshold. But importantly, from the point of view of the application for interim relief, that the Upper Tribunal found that this argument or this claim, part of the claim, was arguable, and it was that suffering that she was seeking to prevent when she granted the mandatory order. And that brings me on to the balance of convenience. My Lord, tab 14, National Commercial Bank of Holland. And I should say, my Lord, obviously all these arguments on Article 3, even if your Lordships were to conclude that the threshold for Article 3 wasn't clear that it would have been breached in this case, she was looking at a situation where clearly there was a serious interference with Article 8 rights from the failure to take proper steps to reunify and the impact on the children. And she was also looking at a situation where further delay could lead to a breach of Article 3, because that's what she had found in the grant of permission. So tab 14. And 179 to 184. The test that she had to apply, whichever course, and this is in the head note at E, whether granting or withholding an injunction is more likely to produce a just result. The basic principle is the court should take whichever course seems likely to cause the least irremediable prejudice to one party or another. And it applies whether the injunction is probatory or mandatory. And so that is the familiar test. And then at paragraph 19, the court confirming that the principles apply to mandatory relief as well as prohibitory relief, and that any discussion about that is barren. And also disapproving at paragraph 21 a box-ticking approach, whether a high degree of assurance needed to be reached in the case of a mandatory injunction. So that's the ordinary approach. And my lord, the question of whether, I think in the end, my learned friend accepted your lordship's remarks in relation to Zalis, that the approach that the
Sorry, in relation to.
Zalis,
Mr. Justice Saini.
Oh, sorry,
Mr.
Saini.
Justice Saini,
Yeah.
that the approach that the Upper Tribunal had taken in a case where it might be said that the relief on an interim basis sought amounted to final relief complied with the ordinary approach, which is that a particularly strong case or stringent test, particularly strong case was required. And in my submission, it obviously does. That is the test, and so there is no error in that regard. But it is important also to bear in mind that this was not necessarily, and this brings me to another of my learned friend's submissions, this was not necessarily final relief, because as your lordship pointed out, the outcome of a negative decision at the final judgment would be that the Secretary of State was not obliged to make a decision on entry clearance at that time. And so at that stage, the family could be removed to France together. And my lords, the Secretary of State has suggested that that option is not available because there is currently no returns agreement. But as we have pointed out in the skeleton argument, there isn't a returns agreement in relation to the return of children either. If there is a risk, as my learned friend has said, of creating a precedent in relation to people smuggling that the French agree with and seek to avoid, there is no good reason why they would not be prepared to agree to the return of this family to France to avert that risk. The Secretary of State's argument on this point is that she is having to rely on an obligation under Article 8 of the European Convention on Human Rights. But there is no evidence of that reliance in any of the correspondence with the French authorities. So you will not see a discussion between Mr. Hobbs and Mr. Janon about the French being required to receive the family on the basis of the Article 8 risk. What is said instead is that there has been an agreement that it's important to avoid establishing a precedent.
So is your argument that it's right, that if it's right that the French authorities are willing to accommodate the Secretary of State's request to take the children back now,
Yes.
there's no reason to believe that the French authorities would not be equally willing to take the whole family back if the parents are admitted to this country and the decision is that they should go.
Yes, and there has been no request. That has not formed any part of the discussions with the French authorities. It has all been put on the basis of will you accept the children back? But no one has asked the French authorities, so they simply don't know what the answer is as to whether, in order to avoid this harmful precedent that is said to be created, and I've made some submissions about why it might not be, but why they would not also agree to the return of this family.
One possible reason might be that there's a larger cohort. It might be that there must be a larger cohort of families in that category. But there must be a larger cohort of families in this country who are adults and children. And there are children who arrive in these circumstances, of which these two are.
But this entire set of discussions that has occurred after the Upper Tribunal's judgment has been bespoke. It's not about a category. It's about this case And what you will see in the correspondence is it's all about the facts of this case, the accidental separation, the children getting the order in the upper tribunal. Now, an agreement with the French authorities to deal with the unharmful precedent said to be set by this case is equally available in relation to the whole family as it is with children. It does not establish, it does not necessarily encompass a wider group of people, and there's no reason why it should, because this is bespoke. So that's the first point to make on that.
What about, everyone seems to assume that if this is to be done lawfully, it's got to be done using the mechanism of the Hague Convention. Would the mechanism of the Hague Convention be available if the children and parents had been reunited in England?
Well, it would be the simplest thing and quickest thing in the world for a family to be removed to France using the ordinary policy of inadmissible asylum claims.
I'm not about the problem at this end, I'm talking about the problem at the French end.
Well, the only thing that is required is an immigration decision to admit the family.
Well,
There's no family law
French,
consequences.
sorry,
I may have misunderstood you.
the French could, if it's just an immigration decision by the French that's required, they can say that's fine, we'll have the children. They wouldn't have had to go through the Hague
That's
mechanism
because the
at all.
children are separate. But once the family are together, then you don't need to go through Hague because the family are with their parents. The Hague Convention is all about transferring
No, well, that's the very
children.
point I was making to you, but you're saying, okay, you couldn't use the Hague mechanism, but you could use ordinary French immigration law.
Yes.
But I don't know what ordinary French immigration law is. Do they have does the French minister just accept anyone he likes from outside the law for a policy reason? Maybe he
Well,
can.
that is what is said to have been agreed in this case. There is no process.
Yes, I see.
There is no immigration process for the children currently to enter France because of Dublin, after Dublin 3 ceased to apply to the
Quite.
United Kingdom.
Quite. That's why they've got to use Hague.
Well,
as I understand it.
Hague is the process for achieving a return which complies with family law requirements, in other words, of unaccompanied children. But it is not the agreement that applies to the question of whether the children can be admitted as a matter of immigration policy.
No, but
So
no,
the
a
sections-
country can't say I've signed up to Hague, all the correct procedures have been followed under the Hague Convention, but as a matter of immigration law, I'm not going to allow the child back into the country, be reunited with the parents.
It can, my lord.
Can it?
Yes.
I would be completely unsurprised if France did not take that position as a matter of law. This is your point, that in the particular circumstances of this case, the reason why the Home Secretary is personally talking to her counterpart in Paris, precisely because
Yes.
whatever a court says under Hague,
Yes.
the French state has no obligation to let foreign nationals onto its territory. But your point is that they appear to be willing to contemplate that possibility in the very particular circumstances of this case.
Yes, my lord.
What speaking for myself, I find less plausible, frankly, is that they would be willing to do that if the entire family were united in England, because they might just say, well, it's your problem now. You've got to decide on their application for asylum. We're not going to do it.
Well, my lord, my argument about that is that that is not consistent with the agreement that is said to have been reached, that this particular case creates a dangerous precedent.
Yeah, I understand
For
that.
other cases.
I understand your submission.
So either it does or it doesn't. Either the French believe that this is so important that they should create a bespoke immigration process for these children or the family to arrive, or they don't. Now, in my submission, it would be unlawful for the Secretary of State to use the Article 8 the interference with Article 8 that is caused by the ongoing separation as a means of effectively putting pressure on the French authorities to agree to something which they would not otherwise agree to. And what it suggests is that the French do not, as is claimed, and we have seen very little, there's no witness statement from the French authorities, and there have been witness statements in cases like this before. And in fact, what you'll see from the disclosure that accompanies Mr. Hobbs' statement is that the French have been asked for a witness statement and have not, or for a statement, a formal statement of acceptance, but have not provided it. So either it is not, in fact, they're not in fact as concerned as they are, or if they are that concerned, they ought to agree to the return on this individual case of the entire family. And and if they are not, then that is part of the balancing exercise, whether if it's not Article 3, that has to be applied by this court, because the question is it justified to continue the separation of this family and the harm to these children in circumstances where the French authorities do not consider that the public interest in deterring smugglers is sufficient to provide a process which doesn't harm the children by readmitting the entire family if their application is refused in the United Kingdom. So, and my lord, that is one of the points that the upper tribunal judge made in paragraph 12 of her judgment. See, she said that the Secretary of State was not precluded from exploring the removal of the family to France if any application was refused. My lord, I want to briefly address the section 51 point. First of all, I should say it's not a pleaded point. It didn't form any part of the Secretary of State's grounds of appeal and has not been pursued as part of their submissions in the skeleton argument. And in my respectful submission, when you look at section 31, 5A and 5, it applies expressly to quashing orders, whereas, as you will see from the remainder of section 31, the power that is given to courts to grant both final orders and interim orders includes mandatory orders and other declarations. That is not covered by this particular provision. And so in this case, a mandatory order was made in the ordinary way to admit the children, sorry,
You
the
say in the
parents.
ordinary way, I don't know what you mean.
Well, it is not a, I can't say, of course it is an order that is exercised in response to certain types of illegality which don't often occur. But there are examples, and the upper tribunal was presented with them where the courts have made these orders. So as part of interim or final relief. So in the ZT,
We've been presented
yes,
with them.
ZT Syria. Which is in the bundle at 251. So that's authorities bundle 1. And what you will see in the head note is that the Court of Appeal considered a decision where this is at F to G, where the upper tribunal allowed the claim and issued a mandatory order requiring the Home Secretary to admit the first 4 claimants and examine their claims, provided they first sent a letter to the French authorities. Now, in the end, the court concluded that the wrong test had been applied before granting the mandatory order. And they explain their reasoning at paragraphs 90 and 100. but they did not conclude that there was any other error in the fact that a mandatory order to admit had been granted in that case. So as a matter of law, it was available. Similarly, in a different context where there's been an unlawful removal, it is, I won't say common practice, but it is one of the forms of relief that is available. And you can see this in PN Uganda, which is in the authorities bundle at 464. And you'll see at paragraph 11, the court, this is a case in which a stay had been imposed on an order to admit and was lifted by the Court of Appeal. But you'll
Yes,
see there,
this is a classic.
this is a
Bring
classic.
them back from abroad.
Yes, but again, these are the mandatory orders
Yes.
that are available in relation to immigration as a response to illegality. It's not a decision. The point I want to make now.
I'm sorry to interrupt you. Would you accept that what a court or tribunal cannot do is simply exercise the underlying statutory function? So, for example, if there's, I don't know, a local authority has the power to issue a grant, the court can't pretend that it is the local authority and issue somebody with a grant. So substitution in that sense is not permissible, but, and it may be a fine line, and it's a nuanced line, but your point is that courts and tribunals, when called upon to do so, do make orders which, in substance, get you a particular outcome, but without pretending that they're actually in the shoes of the relevant authority. So, but that may matter in this case, because would you accept that what the tribunal has no power to do is to grant entry clearance?
Absolutely. And that would have been a substituted decision. But no such decision has been made here. All the tribunal has done is exercise the power that it has been given by Parliament to grant a remedy where it's just and convenient to do so.
Yeah, just to forgive me, so what they've ordered the Secretary to do is to admit someone into the United Kingdom without purporting to give them, as it were, some kind of document which says
Yes.
this has the legal status that you can now live here forever, etc., limited time. And that's, you say, analytically, that's indistinguishable from a fairly routine case to which my lord refers, where we get an overnight application where somebody's wrongly been sent to the Democratic Republic of Congo, and we order that the Secretary of State's got to bring them back.
That's right. There is no difference between it. It's not a substituted decision. As your lordship says, I accept that there may sometimes be a fine line, but the reality is that the availability of these orders, which pre-existed, of course, the statutory context, but have been preserved in the statutory context, are the common law's response to illegality.
And this was long the law. I'm not sure, unless Sir James tries to persuade us otherwise, I'm not sure that Section 31(5) and 5A really did anything more than a bit of statutory tidying up of what had been the common law for a long time. You know, Shah says this, you cannot exercise the underlying power because you haven't been given it.
Well, my lord, it's more than that in my respectful submission. What Section 31(5)(a) actually does is give courts and tribunals the power
Yeah, I know.
to substitute
Exactly.
decisions. So they are given a power that is not normally there.
Exactly.
So courts do.
Well, isn't that just tidying up? That
Yes, that is the
probably did all. The power probably was always there for courts and tribunals.
Yes,
Yes.
but it hasn't taken away anything. What it's done is reflect the position, of course.
Speaking for myself, and I dropped a hint to this effect, I think,
Yeah.
to Sir James. I don't think that I quite understand why you raised the point. It's of interest in another case, but I don't think it's really at the centre of this appeal.
No, well, I just
So, as I say, I see why you've raised it, but shall we move on from it and this is more you have to say?
I want to come on now because I've got limited time left to whether there were any errors in the other
Yes,
areas,
right.
apart from, so the argument about the mandatory order is effectively gone. There is no basis for criticising the use of a mandatory order in this case. The question is whether she was correct on the material before her to conclude that the balance of convenience lay in
Well, you
favour.
don't even have to say correct, whether it was a decision that was open to her. Yeah.
Was it a decision that was open to her? I've shown you the Article 3 argument, but MIK also deals with the Article 8 argument, and it imposes what is indisputable, which is there is, or it reflects what is indisputable, which is a positive obligation to take steps to reunify families where the state has control over their circumstances. So in this case, the Secretary of State, as soon as those children arrived, had a positive obligation to take whatever steps were necessary to achieve reunification. So MIK, just to give you the paragraph numbers, is 82, 85 and 90. That's again in Authorities Bundle 840 to 842. RSM at paragraphs 84 and 163. So 351, the Authorities Bundle, and 366 to 7. And to the extent that the Secretary of State says she does not have such a positive obligation, that is wrong. And indeed, it's quite hard to understand how she can, on the one hand, advance that she has no such obligation, and on the other hand, suggest that the French have an obligation to receive the children.
I may be wrong. Sir James will correct me later if I am wrong. I had not understood his submission to be that, as a matter of principle, there is not a positive obligation on the United Kingdom. Rather, that in assessing what the scope of that obligation may be, what the Strasbourg Court has frequently said is that you have to engage in a balancing exercise.
I think he was criticising what he took to be what the judge was saying, treating positive obligation the same as absolute obligation. I agree, she says positive obligation, but his submissions were more making the point that it wasn't an absolute obligation.
Well, my lord, that is in my submission not a reasonable interpretation of her judgment. She says there's an obligation. She's found that it's arguable that it's been breached on the facts of this case, and she then goes on to assess where the balance of convenience lies. I mean, again, this is a balance of convenience test, so there's no conclusion as to whether, on the facts of this case, it's been breached or not. What there is an argument that it's arguable that it's been breached because of the delays that have taken place. I mean, I've made the arguments as to why they apply to Article 8 as they do to Article 3, and that obligation has not been complied with due to the extensive delays that have occurred. And so she was right to conclude that obligation was engaged, and that in those circumstances there was a basis for granting interim relief. And she applied the high test, and that argument has also not been seriously pursued in the light of the Lordship's observations on Salis. She concluded at paragraphs 4 to 7 that there was a particularly strong case, and given the evidence that I have shown you, she was plainly right to do so. I've made the arguments as to whether interim relief would in fact amount to final relief in this case. There is a strong argument that it would not.
But in a sense, that's icing on the cake from your point of view. She took the case at its highest. She said, maybe it is final relief, but I'm still going to do it. And
she did.
Although she then later made the point that you drew attention to. But
Yes.
As I read it, she said that even if it is final relief, perhaps we have another look.
She did.
Yeah.
No, she took the case at its highest, but I draw attention to the fact that it does not necessarily have to be that way. And so when my learned friend suggests to you that, particularly in relation to the public interest, that the balance fell the other way, it is important to acknowledge that there isn't clear evidence that the French would not readmit this family.
Yes, we have that
And
point,
we've
as you
got
say.
that point. As far as the public interest in deterring smugglers from forcibly separating their children from parents, she reached the conclusions she did about it being speculative.
No obvious logic and little more than speculation.
Yes, and that is because the way it was put in Miss Amalek's statement,
Number one,
as
is it?
which is in supplementary bundle 1,
But it is statement. His first statement.
it's her first.
Perfect beginning, her first statement.
It's her first statement. And it's at 288 to 296.
Tab 48 for those of us lucky enough to be given tab.
And she says at paragraph 11, in fact, my lord, I would like to draw to your attention the paragraphs before that, because what she describes in paragraph 6 to 10 is that this issue of unaccompanied minors relying, or rather parents or family members of unaccompanied minors relying on the presence of unaccompanied minors in the United Kingdom to obtain leave to enter is not a new one. The Secretary of State has a policy about it because of unintentional separations, in other words, unaccompanied minors travelling alone, is a frequent occurrence. And so the Secretary of State has adopted a policy which she describes at paragraphs 9 and 10 of not permitting for refugee family reunion, except in, as she puts it, compelling and compassionate circumstances at the end of paragraph 10. And that is the way that what she has done in order to, she says, deter such travelling in future. So there is already a policy to deal with this particular issue of intentional separations, either at some earlier stage in the journey or at the boat. And she then says of this case, at paragraph 11, whilst the circumstances that led to EK and SK being separated from their children are not clear, with at least 2 differing accounts having been given, so it appears she doesn't accept that it's necessarily accidental, and she does not take that factor into account. There is undoubtedly a clear and significant risk that would follow. Officials assess that there is a real risk that allowing parents to enter the UK because their children arrived in the UK unaccompanied on a small boat will lead to more children being placed on small boats unaccompanied. Now that is the full extent of the prediction that is made in the...
Yeah, you've got to read it with the next paragraph. Or the first,
Oh yes,
the first
I do apologize.
sentence.
Yes,
of the
will
next
be
paragraph.
incentivised to split families forcibly, cause children to be separated from their parents and their lives risked during the crossing. And she then says, she then starts, gives evidence about
And the rest is then about just how dangerous it is for these children. It's not so specific.
Yes.
I think you're right. That is the only statement of the risk that people smugglers will exploit such a decision.
Yes.
And it is the case that in a subsequent witness statement, Dr. Elimelech does amplify that and explains a bit more how the incentives should work to do with payment
Yes.
and so on. That explanation is not given here.
No, it isn't.
At this stage of your argument, you're on simply whether the judge was right to reach the decision she did on the material before her.
Yes.
In case we're not with you, you may in due course want to say something about the
remainder.
But you need to say more than that. This by your submission is this by itself doesn't really explain anything to the judge, and it's quite understandable why she said A, speculative, and B, implausible. I forget what the
No
adjective
obvious
was.
She
logic.
says-
No obvious logic.
Why do you say it supports no obvious logic?
Well, my lord, what appears to be to be referred to. That's why I highlighted the fact that there was no reference to the fact that this was an accidental separation. So what she is saying is that that allowing these parents to come in this against the backdrop of this accidental separation and suggesting that that is going to lead to
I see.
deliberate separations. There's no logic in that argument.
Well, the evidence is in paragraph 11. Right?
Yes, not clear.
Dr. Emily acknowledges that circumstances aren't clear, but despite that, not ruling out the possibility that it was accidental, whether or not it was accidental, she says there is undoubtedly a clear and significant risk that would follow. Why is there not? What is the basis for which that's not an obvious? Why is that no obvious logic there?
Well, it's not there's no obvious logic between here is a family who underwent a wholly exceptional attack on the parents, with the children being left on the boat and the parents on the shore, as the father tried to save the mother from the attack, leading to a grant that's made on that basis, leading to deliberate separations. Because obviously in any future decision to whether to grant leave or not, the fact that the separation was deliberate as opposed to accidental would be taken into account.
Yes, but from the point of view of the people smugglers, that would be a refinement they wouldn't really be interested in. They would say, if you send the children ahead and don't put the parents on the boat, the receiving the English, the UK government will, in practice, accept the children. They won't go to refinement. Oh well, they might not do so if they thought it was deliberate. Anyway, no one would in practice ever be able to stop it anyway.
Well, the incentive is the grant of leave. That's the incentive. So it's obviously relevant if the grant of leave is confined to these exceptional circumstances. I mean, I don't want to spend any more time on that, but she was right to say it was speculative. It was a very brief evidence, not based on any, and not fully reasoned or supported with any anything other than that assertion, will undoubtedly be incentivized. She hasn't explained why a grant of leave in these exceptional circumstances would lead to that incentive. So that's as far as I
It
can.
has to be considered, doesn't it, in the context of the rest of that page,
Yes.
the risk of harm.
Well, I don't. There's no doubt about the risk of harm to children, but the risk of harm to children arises whether they're unaccompanied or accompanied.
Well, that's greater if they're
It's greater if they're unaccompanied. Of course, accept that, but there are unaccompanied children. That's the point I made at the start of this argument. The unaccompanied children come to the United Kingdom on boats.
It's unusual for unaccompanied small children to come. Teenagers come a lot. Yes.
Yes, it's unusual for unaccompanied small children, but the danger that is being described here, including the 2-year-old boy, for example, is a danger that applies to accompanied as well as unaccompanied children. No one is disputing that, and neither did the judge. The issue was there going to be now a new practice adopted of deliberately separating children as a result of this grant of leave? And she says what she says about the likelihood or the speculative nature of that evidence. But she also, part of her reasoning, is the point that I've already made, which is there's an alternative point, which is that that there is another way of meeting that risk, which is that the Secretary of State is able to remove the whole family. And in any event, the balance, remembering, of course, that the balance that the judge has to strike is between the harm, the certain harm, that was the evidence before her. She had the certain harm to the children, these children, long term, attested to by psychiatric evidence and the foster carers, versus this speculative harm which could be dealt with in other ways. And finally, on her statement, my lords, if I could draw your attention to paragraph 18. The Secretary of State accepts that in certain circumstances, children may be able to reunite with their parents in the UK, where there are exceptional and compelling circumstances, but that will require a consideration of all the relevant circumstances of the individual case, as well as relevant policy considerations. And my lord, in my respectful submission, that's the nub of it. No one is suggesting that there must never be a case in which parents can be admitted to join their children, and that in all cases the decision must be that the parents, that the children must be sent back to France or wherever. No one is suggesting that. The Secretary of State is accepting that there will be circumstances in which.
Not necessarily small boat cases.
All cases from France either. Is that paragraph only dealing with children in this context? i.e. children who are coming over in small boats and from where France is the other country, or is it dealing with is it a more general proposition?
Well, she then goes on to describe the danger, and she says she doesn't say that there must be only one outcome. Indeed, that is why she is awaiting the family law proceedings in this case to see where the best interests lie. So, I mean, one of the reasons why, when we come briefly to the new evidence, and I have dealt with this in the skeleton argument, why the family law proceedings are not an answer in any event, or the outcome of those proceedings to this risk, is that they may ultimately conclude that the best interests of the child require the parents to come here rather than go to France. So the point there is that there isn't, the Secretary of State's position is not that there is an absolute rule that is required in order to avert this risk to the public interest. It is that exceptional and compelling circumstances are there. And
might that be a good reason? If we reach that stage, and I have no view on this whatsoever, but if we reach the view that the first instance judge did err, then I think you would accept that we would have to perform the balancing exercise for ourselves on whether to maintain the injunction pending a fine. Are these two factors relevant if we do reach that stage? One, we know that there is going to be a final hearing before the upper tribunal. And two, we know that the family proceedings are now underway. And there be some reason for awaiting the outcome of the family proceedings, precisely for the reason you just gave, that they may conclude that the best interest of the children are that there should be unification in the UK.
Well, my lord, no, because of the evidence about the ongoing harm to the children. And any further delay causes further harm. We are talking about 5 months already. And so from today, the 17th of December, even to the upper tribunal hearing on the 9th of February is too long for these children. And certainly to the conclusion of the family law proceedings.
So does that have the practical consequence? If that submission is right, does it have the practical consequence that the family proceedings are redundant?
Well, my lord, the family proceedings are already based on an assumption that the United Kingdom will not grant leave to enter to these children. So the family law proceedings probably would not be redundant until the upper tribunal had made its decision on the 9th of February. So that wouldn't be redundant as a result of the interim order. There would then be a question depending on the reasoning of the upper tribunal on the 9th of February, as to the circumstances in which the family law proceedings would continue. If, for example, the application for judicial review was successful, then a decision would have to be taken on entry clearance.
Is it possible, I mean, we're assuming the 9th of January, but it might not.
Well, it may well, there's always the potential for delay.
Applications to adjourn.
Yes.
Well, but your fundamental point, basically seems to me to be right, so Jameson trying to disabuse me, is if the upper tribunal say, well, we may have got on this hypothesis the interim order wrong, but on the evidence before us now, and more time has passed, and avoiding such errors as we were held to have fallen into, we still think now that a order should be made for entry clearance, and if that is not appealed or not successfully appealed, then there's no real role for the family proceedings that we have now, because, as you say, they're premised on the parents not being able to come to the UK.
Yes.
There might be a need for some other form of family proceedings or court involvement to see the circumstances in which the parents are allowed to resume care of their children. That might need to be supervised in some way. My lord will know more about that than I do, but that wouldn't be these proceedings.
No, my lord, and in my respectful submission, insofar as it said that that's a disadvantage, it obviously isn't. I mean, there are, and we've highlighted the anomalies in this particular application in the note that we handed up this morning, but also in the skeleton argument. It's unusual to use this jurisdiction without a clear position on whether an order is to return is sought, and particularly unusual to do it on the basis of what appears to be a misunderstanding of the law, which is that there isn't a right to leave to enter to the UK, when in fact there may well be. That's the issue in front of the immigration court. So clarity.
The trouble is, there's a terrible risk of chicken and egg if they don't get on with it.
No, well, I understand that, and in fact, you will see from the submissions that were put in by the parents that they accepted in the family division that these proceedings should run concurrently because of the need for speed.
Yeah.
So that was the parents' submission in the family division. But from a point of view of logic and clarity, it obviously makes sense for the immigration proceedings to conclude before the family proceedings. So it would. So I think I've given a clear answer to your question, which is that the interim order would not, but the final order would affect the family proceedings. So, my lord, in relation to the other points made by the upper tribunal, she was obviously right about and this is her reasons at paragraph 8, about the absence of an existing process for return to France. I mean, that is a conclusion that cannot be impugned on the evidence, and indeed the extraordinary efforts that have been required since demonstrate that. This is all in our skeleton argument, so I'm going to take it briefly, given the time. She was also right that there seemed to be little understanding of the legal barriers at that stage.
What did she mean by the legal barriers?
She meant Hague and all the family law provisions. So what had happened at that point is that there had been general discussion about an ability to return to France, but without that, none of the evidence before her properly or engaged at all with the legal mechanism by which that would have to occur. And what we have seen, I mean, it's really the point that your lordship made, which earlier on in discussion with my learned friend, which is that children can't just be put on boats and sent as a matter of immigration law and returned to other jurisdictions. A proper process involving the family courts and family laws courts jurisdiction or family divisions jurisdiction is required. And there wasn't an acknowledgement of that, a proper acknowledgement of that at the time of the hearing before her. So for all those reasons, my lord, and those set out in my skeleton argument, it's clear that the upper tribunal was not only entitled to reach the decision that she did on the evidence before her, but was right to do so. The balance of convenience plainly lay in favour of putting a stop to the ongoing harm to these children immediately. And insofar as it is not clear precisely what the judge meant about logic, that phrase has to be seen in the context of her other assessment of that evidence about risk, smuggling groups, which is that it was speculative, which was obviously correct based on what was before her, and also her conclusion that there were other means of meeting it. Now, my lords, in terms of if your lordships are not with me and you examine this new material and assess the balance of convenience for yourselves, again, I've dealt with that in the skeleton argument and rely on those submissions, but really it's the same point, because even with all the efforts that have been made that were not made before the upper tribunal, there is no clarity about exactly how long it's going to take for the children to be removed to France, or even, and there is no clarity about whether they will be removed to France. And so what the Secretary of State is asking this court to do is to lift or uphold the appeal against the decision on interim relief on a basis which is not clear, in terms of an outcome that is not clear. We may be in the same position in what will be at least 2 months' time, so that this delay and harm to the children will have been for nothing. And when you balance that against the possibility that these parents can arrive tomorrow, all the immigration documents are available. They could be on a flight to the United Kingdom, putting an end to the suffering of these children tomorrow, versus a wholly uncertain outcome.
Would they be united with the children?
There is an arrangement that has been agreed with Kent County Council, which is a staged process of maintaining contact until the children are assessed to be ready. So
The parents have agreed that
They have
provisionally with Kent.
yes, they have.
So no order would be required.
But they would be physically here and able to
See,
hug their children. I mean, this is the reality.
there's two problems. There's one, there's an emotional readjustment, and but there's also practical questions.
Yes,
You can't
where they're
think
going
about
to live.
where they're going to live and so on.
Yes, so the parents have agreed to Kent supervising the contact that initially occurs. But
All by consent under the Section 20 umbrella.
yes, I understand. Yes. And so there is really no contest in terms of the balance of convenience. And as far as the public interest is concerned, I've already made my submissions about the alternative routes that are available to the Secretary of State in order to protect it. And there is one final.
But there's only
Yes.
the only alternative route is, having reunited them here, then to attempt to return them, to get the French to agree in the rather different circumstances, to have them back again afterwards. So we said that's the only alternative route, isn't it?
Well, my lord, I do continue to say that the terms of whatever judgment it is are important. I mean, what is being said here is that these smugglers are going to find out about this, and I want to come to that very briefly, because there is
Yes.
another possibility, which is that you deliver a private judgment in this case. There's no reason why the smugglers have to find out what you conclude. Private judgments in the family law context are common, but there are other ways of preventing it. But even if
Private judgment is not that common. Not
No,
anonymised
I
judgments.
do apologise. If I have overstepped on that, but it's yes, but at least it is an available option for the for this court, and if necessary, and the Secretary of State has not asked for it, that is one option. But I do say that the terms of the judgment are also important. What is being said is the smugglers are going to find out, and then they're going to do something because of what has been found out, that there is an option. But if your judgment makes it clear that this decision is made on the very specific facts of this case, there is not an incentive. Now, I know your lordship has said, well, the smugglers won't distinguish between these reasons, but but what is precisely being said is that the smugglers are very acute to these changes in immigration policy. And if your lordship's judgment makes it clear that the circumstances of this case are extraordinary, then that is a factor
The
that must be
extraordinariness on
relevant.
which you place your weight was the delay.
And the accidental separation, yes.
I mean, the delay seems better than the problem about accidental separation is if it is known that if it's accidental separation, that is what smugglers will tell parents they have to say if they want to see their children again.
Well, my lord, I do say that there would be ways of of investigating that, but I accept the delay is the biggest factor in this case. That makes it an unusual case, and that is what I rely on. So there is that.
Is your proposition that there should be a private judgment?
Well, my lord, I'm simply raising it as a possibility. What is said? Yes.
This case has had some publicity, hasn't it?
Well, yes, it has, and the publicity to date has not been said to create the risk. So what is being said to create the risk is the outcome. So if the outcome is unclear because it's in private, then the smugglers are not going to find out about it. My lord, these are options that are available in the extreme circumstances of this case, and in my submission, they ought to be considered before inflicting certain harm on these children. There are other mechanisms of ensuring that the public interest that is relied on is protected. And my lord, one final point before I sit down is that in the correspondence with the Secretary of State in the discussions with France has made clear that they are very keen for the United Kingdom to agree a returns agreement, a general one, in other words, not a bespoke one. So they have raised that in the specific context of this case as providing a solution to this problem. Now, that is also something that is on the horizon. So the public interest that is being invoked in this case may, in fact, not arise if that agreement, or the risk to the public interest, I should say, may not arise if that agreement is reached. And again, in my submission, the efforts that are being made to stop this family in reuniting in the United Kingdom should be spent instead on very belatedly providing a replacement to Dublin III, which was a returns agreement which dealt with all these matters. My lord.
Thank you very much, Mr. Gilroy.
I don't know whether you want to hear from Kent or you don't.
Well, in the end, and I think wisely, although that note is on the record, it's not really formed any part of Mr. Gilroy's substantive submissions. And don't give us the whole submissions now. What really did you want to say to us, Mr. Southey?
Well, Lord, I think between the two of us, myself and Mr. Devereux, there were two things we thought we might need to draw to the attention. The first, actually three things. One, just to make clear, the facts or the instructions I gave this morning were specifically no child as young has been separated on the beach as these children. That's not inconsistent with the evidence. Secondly, obviously, my learned friend Mr. Kilroy has made some submissions about culpable delay. Culpable delay. As we understood it, those submissions were directed at the Secretary of State.
They were.
Absolutely, and we would strongly urge the court not to say anything about any fault on the part of Kent for a range of reasons, not least, but not the only one, the fact that social workers have obviously been dealing with a difficult situation, and it is unhelpful to be critical. The third thing was that there were some sort of remarks about what various sort of family procedures, and in particular what would But I think if the parents consented, my learned friend Mr. Devereux could provide further information about that if it would have if it would assist.
Thank you. Just before we ask Mr. Deborah, it's very difficult in a case like this where there's obviously a very powerful human story.
Yes.
We've said nothing about that. I wouldn't want anyone to think we're not very alive to the powerful human interest, but we're here to decide the law, not about that. But the reason I say that at this point is that it's evident that in many respects, perhaps in all respects, the children have been extremely well cared for by Kent and by those whom they have appointed. I don't want to go into a paean of praise because I just don't know. There may be more we don't know. But I think anyone who's read the material would see that Kent and the foster parents have made impressive efforts.
Thank you. That is appreciated, and it was more that we just wanted to.
I know you did. I've been wondering a little while whether to say something about that, but in the end I thought I would.
Thank you.
Now, Mr. Devereux, if you think, tell us how you think you can be of help to us. At the moment, my lord, whose field this is, may have questions he positively wants to ask you. I don't, but there may be.
I'm not avoiding your lordship's questions, but can I present the 2 points that I think might assist?
Yes, that's it. What are things you want to think we might be interested in?
Yes, the court was concerned about timescale and processes, and in particular the role of the 1996 Hague
That was going to be
Convention.
my question, Mr. Derrick.
Well, it's lucky that
then-
at least
then
one
off-
great mind.
Yes.
The position is this, just to recap in very, very limited ambit. The local authority make their application on the 28th of November under the inherent jurisdiction. There's a first hearing at which the Secretary of State attends on the 29th of November. There's an inter partes hearing on the 10th of December where the parents are represented by leading counsel. The children are separately represented. And that's a very important point to emphasise for those who don't have a day-to-day interaction with the family division. The hearings coming up are 2 sets of hearings. The first is on the 21st, the 22nd and the 23rd of January. And the second is on the 18th and the 19th and the 20th of February. Originally, when the matter was before the court on the first occasion, so that's to say on the 29th of November, the court listed the February hearing dates. In the interim period between the 29th of November and the 10th of December, further availability came about in relation to the January dates. And in fact, before the court on the 10th of December, the local authority was saying, we want to limit delays, so can we have the final hearing in January? It was the parents who wanted to have the hearing in February. In terms of the Hague Convention,
Don't worry, Mr. Kilroy, I know you're looking worried. I'm sure that's not a criticism.
No, it's a statement of fact. In terms of the Hague Convention, that deals with jurisdiction, roughly speaking, jurisdiction, recognition, enforcement, applicable law and cooperation. For the purposes of this hearing, the emphasis that we make is to say that when the French talk about the Hague Convention, and that being the process that needs to be adopted, they're not really giving the whole story. They're focusing on whether you transfer jurisdiction. They're not saying that you need to utilise the Hague Convention to bring about the return of the child. So in the case of A, which are the 2 decisions of Mrs. Justice Knowles in April and July of this year, she found that you can return a child to, in that case, Vienna, notwithstanding the child had made an application for asylum. She didn't transfer jurisdiction. She just used the inherent powers of the court under the inherent jurisdiction. The only point about the Hague Convention that really is material in this case is this. If it is contemplated that there would be a return, and it's not at this stage, but it's one of the possible options, but if it's contemplated that there would be a return to French social care, then there's a mechanism under Article 33 by which the local authority are required to write a report, to consult with the French authorities, write a report setting out the reasons why they wish to place the child or children in care. But if at the end of the day, Mr. Justice Garrido decides that the children should be returned to France, there's no requirement for jurisdiction to be transferred, because the French would have a jurisdiction under, for example, Article 11. If the return were to be to care in France, then there would have to be the mechanism via Article 33.
There's not a transfer of proceedings,
Well, no, it's not.
which you can get is what Article 8 and Article 9 is.
Exactly. And I think
Okay, there's a
I think it
transfer.
can be confusing in the context of looking at processes and timescale to say that the sine qua non of a return to France requires a transfer of jurisdiction pursuant to Article 8 and 9. It doesn't. A
Yes.
child can be returned without that.
Yes, I see. Well, that certainly clarified something which I hadn't fully focused on. I'm told my lords didn't need that explained. to
Just
them.
dealing with a separate point. If the parents,
So just pausing on that,
yes,
if Mr. Justice Garrido were to say the right course is for the children to be reunited with their parents in France, I see no need for them to go into care
yes,
in a French institution. All that's necessary is they be physically returned to France, where they will meet their parents, and then it's up to the parents from then on, subject to the general French law about looking after children. The Hague procedures don't need to be used at all.
no.
Yeah.
But
But French immigration would have to allow them in.
exactly.
But what Sir James would say is that that bit looks like it's going to be solved.
Exactly. Now,
Yes,
to be
right.
fair to the parents, there's a further potential layer of complexity. The first hearing in January is to deal with legal issues.
There were three issues which I set out in Mr. Justice Garrido's order.
Jurisdiction, whether the local authority should have leave under section 104 to bring proceedings under the inherent jurisdiction. And thirdly, and this is the layer of complexity, whether in fact, in circumstances where a child has made an application for asylum or is deemed to have made, a family court has the power to return a child to another country.
Was that decided by Mrs. Justice Gwyneth Knowles?
That was decided by Mrs. Justice Gwyneth Knowles in April in A.
And what her decision was that they could.
They could.
Yeah.
In June, the president, in a case called Re-HR, it's a tab 36 in the authority council, said this is a matter that deserves full argument before the Court of Appeal, because the Secretary of State didn't give argument in the first Re-A. In the second Re-A, which was in July, the Secretary of State came to court and said that he agreed with the reasoning of Mrs. Justice Gwyneth Knowles. But for transparency's sake, it's fair to say that that has not been considered by this court. And there
There
must
was
be
no
a
appeal in
realistic...
that case.
Forgive me.
There was no appeal in that case,
Indeed.
and it hasn't since come up in.
Parents were, there was a difference between the parents in that case, wasn't there?
In that case, there was the maternal grandmother and the paternal grandmother, and the mother were in Vienna. They had asylum from Syria there. The father had taken the children from Vienna, crossed on a small boat, was convicted of immigration offences, was in prison. The children were in care, and the decision was to return them back to Vienna. There'd been a long-standing interaction with the local authorities in Vienna, but that was the rough facts of that of A. If the parents agree to a return, then the local authority, exercising its duties, which it's required to do to safeguard and promote the children's welfare, would facilitate, as appropriate, a swift return. But there would have to be an evaluation, plainly, of how that return best meets the children's requirements. But that happens relatively quickly in all sorts of cases,
Abduction case.
in so-called abduction cases.
And is this right? That would not require any court process
That would
in
require no
France.
court process.
In France, or I
Well,
think even here.
what would likely happen on the ground is liaison between the local authority here and the welfare authorities in France, and subject to the local authority being satisfied here, just to meet their statutory duties, they would then facilitate a return. It would then
Well, that would be practical question. There'd be two questions. One is, are the parents suitable? I have no reason to suppose there would be a difficulty about that, but that would have to be asked. And secondly, more practical questions, have they actually got anywhere to live, where the children live with them, and those sorts of questions.
But absolutely, but the
Yes.
assumption would be that the French authorities are equivalent to our own
Yes.
in general principles, and would be able to undertake the protective way that we
Yes.
conduct ourselves, and to provide all the sorts of services that
Yes.
your lordship indicates.
Yes. They would, from a material point of view, be no worse off than they would be here. There'd be arguments about the fact they've got a client house here, they speak English, they don't speak French. Those are,
Yes.
but that's a different point.
But
Yeah.
if you go back to the A case, there was a relatively limited amount of information from the Viennese authorities. Granted that they'd had interaction with the family for 7 years or so, but the court was prepared to assume that they would be in the same position as
Yeah.
they would be in this country, and would provide the same services and protection and so on and so forth.
Yeah. You wouldn't do that for every country, but
No,
you
you
would do it for an EU country and a country we know well like France. Yeah. Well, I found that helpful. Ms. Kilroy, I think, wants to say something.
Well, Lord, I don't want to spend any more time on it, but I don't accept all of what has been said about the speed and the
About what? Sorry, speed.
about the speed of what could be done here and the factors that would be taken into account. And in particular, whatever happens with these proceedings, it will be necessary for whatever body has to make the decision to properly assess the real circumstances that these children would be in France before any decision could be taken.
I accept that,
Not based on assumptions. I mean, my learned friend suggested you could make assumptions.
well, I think there are different sorts of assumptions, but
Yes.
I certainly have not got to come away with the impression it'll all be dead easy.
There is a distinction between the Viennese case and this
Yes, and there were
one. I think Mr.
multiple.
Devereux alluded to, but
Yes.
didn't need to develop.
They had asylum and they'd lived there for some
7
time.
years.
Yes.
Grand-
Yes,
yeah.
it really, it's just not comparable there in really any way.
No. Okay. Thank you very much indeed. Now, Sir James, I see the time, but we are prepared to sit on a bit to allow you. I know you're always succinct. I don't feel well, certainly don't feel you have to rise at 4. We will be rising at 4:15.
I'm grateful for that small activity. Well, I hope that was of use. I'm pretty sure it was of use, certainly of use for me. So I'm grateful for my learned friend's submissions in that respect. Just by way of replying very briefly, there is in the end really no dispute about the following propositions. The parents can claim asylum in France. There is no serious risk of refoulement from France. They simply have to claim asylum and go through the usual processes. The parents have been and are safe in France, and so would the children be. Our own friend suggested that the subjective fears were not made up. I don't need to go that far, of course I don't. That's simply that. The route to France is open, in principle, as we all now can see. And the parents evidently would not take the position in relation to France that if the children were to be returned there, or indeed if they agreed to cooperate in the way that we say they should, there is any realistic prospect at all of the children being put into care in France. In other words, having to engage that more complicated a process. So the harm that my learned friend relies upon can be brought to an end. And we do respectfully submit that it has at least been capable of being brought to an end by a position taken by the parents. Since August of this year, when it was first indicated by the mother that she did not want reunification to occur in France. And my Lord the Vice President put to my learned friend that the idea of reunification in that way had come up late. The idea of reunification did not come up late. It was raised with the parents in August very specifically. And I want to give you two references without going back to them. The reference to the mother confirming that she does not want the children returned to France is in the email from Kent County Council to the Home Office on the 15th of the 15th of August 2024, Supplemental Bundle 1, very bottom of page 326 with the email addresses, substance of the email, top of page 327. And that remains their position. As one sees, for example, from the passage right in the middle of page in Supplemental Bundle 3, page 60, in the Child and Family Assessment document of the 25th of November. So those matters are not significantly in dispute. I wanted to turn briefly to the harm that is being relied upon, and in particular Article 3. My submission is that the obligation on the state under Article 3 is not itself to treat individuals within its jurisdiction in an inhumane way. It's a negative obligation of an absolute kind, as we know. But what that indicates is that it's an obligation on the state not to treat people in that way. So there is at least a causal question. If harm has been caused by events or even people that have nothing to do with the state. For example, the trauma of an attack on a boat trying to cross the channel as it leaves French waters. Decisions by parents to subject their children at a very young age to the sort of risks that are engaged in that enterprise. And so there is a distinction to be made in relation to harm that flows from that, and it's a little difficult to see how those sorts of events would not have been, at the very least, the most significant contributors to the difficulties and issues that the children have faced.
Well, you may say that, and you may be right, but that's not the case against you. Didn't really focus on those matters. It focused on the effects of prolonged separation, possibly prolonged separation in a case where the children will already have been traumatized by the events to which you refer. But the emphasis is on the prolonged separation.
My Lord, yes, of course. But my submission is it's very easy to say it's all put on the prolonged separation and to ignore the previous causes. That's the way I put it.
Forgive me, Mr. James. The point is that I think Ms. Kilroy's point is that she accepts that, but that these children are vulnerable, particularly vulnerable as a result of all that, and therefore the delay has a greater effect.
My Lord, of course, and I understand that, which is why, with that introductory submission, my primary case under Article 3 is that you don't get anywhere near the level of severity that is required to bring you within that absolute prohibition, with all the seriousness that that entails. And that's essentially the point that's being made over a few paragraphs in the detailed grounds, para 66, our detailed grounds, 66 to 69 in the core bundle at page 318. But the critical feature of all of that is to recognise, so far as the state is concerned, that it has reacted as a state commendably in the sense of scooping up the children, making sure they're properly cared for, putting them into school, putting them with foster parents who self-evidently on the evidence have been extremely caring. and have done an extremely good job, as my lord pointed out, based on the nurse statement. It's absolutely clear that that's the position. They've done everything they possibly can, with some success it appears, to try and stabilise and provide a proper environment. And so the principal obligation on the state to try and mitigate that harm while these issues are being sorted out, important as they are in the public interest, has been fully complied with. My learned friend sought to add as a kind of tail piece to the Article 3 damage argument. There would be damage, fresh damage, worse damage now if the children were to be uprooted now. And the answer to that is, but they would be with their parents. And so even if the uprooting might cause them some distress in the short term, that is more than compensated for by the fact that they would be in France with their parents. And then my learned friend sought to say that the Article 3 issues were in some way made worse by what was being presented in effect as a contempt point in relation to what the Secretary of State did immediately after the upper tribunal hearing and by way of compliance or purported compliance with that order. I'm not going to go into all the detail of that, but I do want to give you some references in case that becomes important for you. The hearing occurred on the 31st of October. On the 1st of November, Supplemental Bundle 1, pages 75 to 80, the Secretary of State applied to the upper tribunal for a stay of 72 hours after receiving the reasons.
Yes, I see. So the reasons we saw, I think we were told this didn't actually, weren't available.
4th of November.
4th of November was the next date. They give their reasons, but they do not address the stay at all at that point. And so it would be an application current for 72 hours after that, which would take one to the 7th. But the order, as you know, the phraseology of the order was to make the arrangements as soon as reasonably practicable. It might be said, well, you should have gone back to the UT and said extend the 72 hours because the Secretary of State, which is the next event on the 13th of November, then applies to the Court of Appeal. There still having been no decision or reasoning from the upper tribunal in relation to the stay application within the 72 hours after the reasons were given. At 13th of November, the Secretary of State applies to the Court of Appeal for PTA and for a stay. That is Core Bundle, page 28, paragraph 37. And then on the 14th of November, there was a hearing before the upper tribunal which led to the order that you've seen. That's Core Bundle, page 225. And the upshot of that was not a finding of contempt or anything like that. It was an order that the Secretary of State make specific arrangements to do with flight or whatever it may be, to allow the parents to fly after 5 p.m. on the 19th. And what that led to was a respectful letter of the 15th of November to the Court of Appeal, saying, we're terribly sorry to tell you this, but everything is going to go into a very bad spot unless a decision is made on stay and PTA, preferably within that time frame. And then that led to Mrs. Lady Justice Lang's order at Core Bundle, page 210 to 214. I should remind the court as well that the stay was
Remind what the
granted.
date of that order was. That was the 19th, wasn't it?
I think that was the 19th.
How the
I think
date-
it was on the morning,
It was on the morning and,
and the thing was happening in the afternoon.
yes.
So, by then it was. We're very, very grateful for that. I'm reminded that I think her stay order was granted until today. So if my lords are going to reserve, it might need to be extended until judgment at least, otherwise we're going to be in terrible trouble again. But I've simply flagged that up. You see that from Core Bundle, page 210. My lords, my learned friend opens our submissions by saying the sins of the parents must not be visited onto the children, which is a proposition with which we can all wholeheartedly agree. And I am not seeking to do so, and I hope I haven't been taken to be doing so. But it is nevertheless highly relevant, we submit, that the parents have been able since August and continue to be able to bring matters to a speedy conclusion. What parents in this situation we submit cannot do is to self-create and then to seek to take advantage of a continuing harm that they themselves have been able or could have been able to take steps to prevent, stop or ameliorate. The parent's position is also relevant, we submit, to the broader public interest, not allowing this to dictate entry into the United Kingdom with all the concerns that that would create. The position in relation to family law I was going to address you on, my learned friend Mr. Devereux has very helpfully saved me that trouble, and I won't do so. I simply note that at this stage, as I understand it, the children are as it were, under the auspices of Section 20, and so if they were to be prevented, were the parents to consent, if they were to be prevented from going, there'd be a very easy process for all the reasons, and speedy process for all the reasons my own friend Mr. Devereux gave. If they were to be prevented from doing that, not precluding, or no one's precluding Kent from taking further steps in the future if that's what they would like to do because they perceive the best interest and not be served, there would have to be an application to do something other than the present position, which is that the parents have a right to bring it to an end whenever they so say. They have to be
They
made
say
wards.
touch-start care proceedings,
Yeah.
interim care order, I suppose.
My lord, that's all I wanted to say about the family proceedings. My learned friend then said two final points I made. The delay was the critical factor. It is that which causes the harm, she says. It is evident, however, that it is not the pure or mere fact of the delay that has caused the harm, because of, inter alia, the hypothesis that my lord the Vice President put to her, which is if you assume that everything did start earlier, there would still be a prolonged period. Now, true it is, of course, my learned friend perfectly fairly says, well, it's a longer period because you have to put the bit on the end, but there would inevitably have been some process and some delay or separation prior to things being sorted out. But my overarching submission is the one that I made in opening in relation to delay, and I don't repeat that. I wanted to finish on the risks and the concerns that the Secretary of State has, and my broad submission is that they are legitimate, real and serious public interest concerns. There are the broader risks, which my learned friend had nothing to say about, namely that no one should be getting on the boats at all, parent or child, because they should be making applications for asylum in the safe country that they arrive in first, such as Belgium and France. Secondly, the specific harm, I respectfully submit that the exchange that the court had with my learned friend was revealing, not speculative, but based on a predictive judgment by an expert person and an experienced person, namely the Secretary of State, with all the resources she can call on, not lacking in obvious logic, because the logic is absolutely clear and was more than sufficiently set out even in Dr. Ellenwick's first statement. It is no answer to that concern to say accidentally split, that provides the break. It doesn't answer that at all. The smugglers won't care. Their logic will be children here equals parents follow. There's the incentive. And how do you tell? Who's going to pay any attention? The smugglers certainly aren't. And my learned friend's final answer was, well, don't worry about any of that, because France will take them back, and that's an alternative route. I leave aside and make no submissions, because I would get in terrible trouble, no doubt, from the MOJ on the basis of the open justice principle, where I advocate a private judgment from this court. So I leave that on one side. But will France take them back was the more significant point my learned friend made. And the answer to that is that it is, in short, very, very far from clear that they would do so. They would be under no continuing Article 8 obligation themselves. So that mix wouldn't have to be put into the balance. The family would all now be here. and it may be relatively easy to see France saying, well, the world has changed, we're going to take a different position, leaving aside what the position would be in relation to the immigration issues that might arise in that circumstance when the whole family is outside and is trying to get back. So we respectfully submit for all of those reasons that this is an appeal which, despite, and we still recognise the human side of it, this is an appeal in which we invite the court to allow the appeal on the basis that the other party did not have proper or good or sufficient reasons for imposing the mandatory rule that they did.
Thank you, Sir James.
Oh,
You're
can I
being,
remind you again
prompted
of
from behind.
Can I remind you of the stay whilst I read this?
Yes, I've got a note of it. I had, but perhaps I would pass it past you.
Thank you.
We are going to rise for a moment, not, I'm afraid, to give you to come back immediately with a decision, but simply to tell you what happens next. But easier if we do that outside. But we won't be at all long.
Rise and table.
When they come back in, I'm going to invite them to receive further material. So I'm not, I'm going to introduce your application for them to receive further material.
That's why I came.
The last 2 weeks have just been crazy.
Is it just one case?
I've got another thing that's building it out. I think that's just nothing works for that. And then I sit in mental health restricted patients. I don't. Yeah, it is really interesting, but I don't really do my fair share. So I decided to fit one in on Friday, just because that's the end term. That's now a mistake, I think. That was a big mistake. But he did it all.
Court, rise the table.
Well, I want to start by saying how well served we have been by the representation and excellent oral submissions, obviously to a considerable extent fed by those behind, both solicitors and junior counsel. And it's always a difficulty getting a case like this ready at short notice, and we have had no cause for reasonable complaint about bundles. Some things have come in very late, but that's entirely understandable in the circumstances. So start with a note of gratitude to all professionals. This is obviously a difficult and sensitive and important case, one where, as I've already said, we are all very aware of the human story which lies behind the legal issues. It's clearly important that we reach a decision as soon as possible. Our present firm plan, unless anything quite unexpected happens, is to hand down a judgment on Friday morning. probably at 10 or 10:30. Details you can get in the usual way. That will be at an actual hearing. However, I would hope that we will be in a position to have circulated draft judgments the previous day at least, so that at least you'll know what is coming, and they will be on a subject to editorial corrections basis, so that they can be tidied up before they go onto the National Archive, and we would hope to be able to deal, and parties should be in a position, as long as they've seen the draft, to make any consequential submissions, and we'll try and deal with them on the spot then. Obviously, no need for the full teams to attend. The minimum requirement will be at least one counsel from each side. On Friday the 20th, I quite understand not everyone will necessarily be available. We will continue to stay until the hand down. We will make the anonymity order in the meantime, and if we are in a position, as I expect and hope we will be, to circulate a draft judgment, it will be on the usual confidential terms, and I won't go through all those again with experienced counsel like this. Can I say in particular, we're most grateful to Kent, who provided us not only with one counsel, but two, in circumstances where all they ever intended to do originally was to intervene on paper, but it's been very helpful having them here.
Well, on that topic, obviously it may depend on the judgment, but can I ask that if seen as appropriate by Kent, we are excused from attendance on Friday, because if all that's in issue is relief, then
definitely no. I meant to say that we only need counsel from the appellant and respondent. Anything else that you need to know between now and Friday morning?
I just wanted to address one point. My learned friend said it was conceded that the French had agreed to admission on an immigration basis, and I just want to make it clear, and you can see this from our skeleton argument paragraph. I've now lost the paragraph now, but it's clear from our skeleton argument that we do not concede that that matter has been settled. The question of whether the French have formally agreed to receive the children back into the country.
To what, sorry?
To receive the children back into the country on an immigration basis. Yes, what was asked for was a formal acknowledgement, a formal acceptance, and you can see this from the supplementary bundle 2 at page 37, and the French reply at page 35 of the same bundle. No formal acceptance has been forthcoming.
Well,
so
thank you for clarifying the extent of your concession. We can obviously see exactly what has been said from the documents. Thank you all very much.
Court rise in favour.
I didn't quite clear what I didn't do my fair share of, but I didn't do my fair share of something.
Make the court aware the live stream is live.
Okay.